then you're not required to be any kind of detective. You're just supposed to do, what anybody, a normal person would do to check the documents.
Susan, we do have another question regarding I-9s.
Yes.
It's a very good question, especially with the level of merger and acquisition activity that's out in the market. This particular individual asks, what if you are hired into a company and you cannot find most of the I-9s from previous years? Can you have all the current employees fill out new forms, revalidate their identification, and then be in compliance?
That's a great question. It's an uncomfortable position to be in when that happens. It's supposed to be part of the due diligence in any M&A activity, but it often gets shunted off to the side, and it does happen sometimes that people don't get to review the I-9s before a deal closes. If you can't find the I-9s and you've acquired a company, then absolutely do new I-9s promptly. The way it works is that the acquiring company assumes the liabilities of the acquired company. So you take the I-9s if you have them, and if there are mistakes on them, you inherit those mistakes. So that's usually why Immigration Counsel is brought in an acquisition situation to help review the I-9s and make sure that they are not going to be adding to the company's liabilities, but that they're in fact done properly, or that they're corrected before the acquisition closes. But if that doesn't happen, then the best thing to do is to, and if there are problems with them, or if there aren't some on file, or you only have some but not all, then definitely you need to do new ones right away. Moving on just to E-Verify. E-Verify is this program that is being advertised widely right now by ICE. Many of you probably have heard of USCIS, U.S. Citizenship and Immigration Services. USCIS is just one division of the Department of Homeland Security that deals with immigration matters. The Department of Homeland Security, which of course was created after 9/11, now houses 3 different agencies responsible for different types of immigration matters in the United States. CIS is the benefits granting arm of the government, and ICE stands for Immigration and Customs Enforcement, and they are the investigators. They're the ones who raid companies to check to see if the workers are illegal or not. And they are also the ones who are responsible for this E-Verify program. E-Verify is this database that the government is encouraging employers to sign up with so that you check the status of all new hires combined with the information on the I-9 document through 2 different databases, the Social Security Administration database and the Department of Homeland Security database. If you sign up to participate in the E-Verify program, then you're required to sign an MOU, a Memorandum of Understanding, with the government, where you agree to comply with the terms of being a participant in this program. And if you decide to sign up with E-Verify, and many of our clients have actually signed up with it, and so far so good. It hasn't really been too terribly difficult for many of our clients to be E-Verify employers, but it's really important that you read the MOU very carefully in order to decide whether you want to sign up for this or not, and so that you understand what your obligations are and what the government can do. It kind of gives them an open door to come in and check your records on a yearly basis. And being an E-Verify employer means that you're going to verify all new hires through the E-Verify database system. So you're performing queries through this database that go directly to the Social Security Administration and the Department of Homeland Security. And you're going to be getting responses back to your queries about the status of this new hire that you have hired and whether that person's Social Security number is correct and whether or not they're legal to work in the U.S. The Social Security Administration and the Department of Homeland Security are going to respond back to your query electronically, either by confirming that the person's okay, that everything matches up, or by giving you what's called a tentative non-confirmation. And then if you get one of those, you only have 8 working days to be able to call the employee in and respond, get them to respond. Yeah, the person often has to go either directly to the Social Security office to clear up a problem, or to the immigration office. And the MOU requires you to notify your workforce that you're an E-Verify employer as you do sign up, and that's one of the things that the MOU talks about. And then there's a certain posters that you have to put on your wall that say that you are an E-Verify employer. A lot of companies have started to sign up for E-Verify over the last 6 months or so because of regulations that have been postponed, but were supposed to have been out by now, requiring all federal contractors in the United States to sign up with E-Verify. Those rules have been postponed again, and it remains to be seen whether the Obama administration will continue to push that back. But a lot of companies signed up so that they could get used to the program and become compliant with it before it would be absolutely required to do so. Does anybody have any questions about E-Verify?
Well, we do have another question, and that is for the verification for a virtual employee who is not going to be at the company office for their first few days, that has a deputy person to physically view the documents. Are there options, or does a qualified person need to physically inspect? And I've read that question pretty much verbatim. I'm hoping that's clear, Susan. I think
somebody needs to physically look at the original documents of that individual to do the I-9. So if they're working in a virtual office and there's nobody who works for the company near that person, you probably have to deputize someone to serve as an agent for the company and meet with that person to fill their I-9 out. And I can have if you want to have a conversation about how to do that after the webinar, my contact information's on the slide at the end, and I'd be happy to talk to you about it.
Very good. Thank you.
Okay. E-Verify, the jury's still out about it. And some employers think it's a great thing. Many employers are worried about signing up with it because they fear that they're opening their doors to the immigration office to come in at their leisure and inspect their documents. The fact is that the employers that are clients of ours who have signed up with it so far have not had any issues with it and have learned how to administer it and have designated someone to be responsible for it. There is a fair amount of administrative gearing up time to participate in E-Verify. It tends to be important to companies that are working in industries where the labor force may not always be legal, and they want to make sure that they're doing everything they can to ensure that their workforce consists of legal workers and it demonstrates good faith. And then some companies that are federal contractors are using E-Verify just even before they need to, again, like I said, to get used to it. Finally, PERM. PERM is this green card or permanent residence application process that every company in the United States needs to go through in order to sponsor someone for permanent residence or green card status if they, for example, don't have a different way of getting permanent residence with the company. Now, a multinational company may well be able to avoid this PERM process for many employees it wishes to sponsor for permanent residence if the employees transferred over, for example, from an overseas office or were managers or executives and are managers or executives here. And then some companies can file permanent residence petitions for workers and avoid PERM if, for example, the person can prove that he or she is someone of extraordinary ability in business or the arts or the sciences, etc. But for just about every other employee, the vast majority of employees on visas in the United States will be sponsored by a company under the PERM process. And that is particularly dicey right now in this economy because PERM requires the company to advertise the job in a variety of media, including the newspaper and online and with the state workforce agency in whatever state the job is located in, and test the market. And only file the application with the Department of Labor if the company can prove definitively that there were no qualified U.S. workers for the job. It's a challenging environment right now to do perm cases in, especially because there have been a lot of layoffs and there are a lot of qualified workers in the marketplace right now looking for new jobs. But there's still plenty of companies filing perm applications for employees right now. Just maybe fewer than there were this time last year, but still quite a few. And it's really important if you go through this process for an employee that you make sure that you comply with the Department of Labor regulations and protect the company against any possible liability with the Department of Labor, which is the agency that governs this process. The postings that have to get done for the green card process with PERM are very different from the H-1B. There is a posting that has to be physically posted on the bulletin board at the company, like with the H-1B. But there are additional postings that have to be made, and it's really important that the immigration lawyer, whoever it is who is handling the PERM case, is very clear with you about what those are, how many days they have to be posted for, how many days the ad has to run for, and to make sure that you have tested the market according to the timelines that are required by the Department of Labor. And it's really important to keep records of all of the postings. If you post on your company website, you have to note the date the posting went up and the date the posting went down. You need a screenshot of the posting. You need to make sure that you can save any of the information regarding any applicants who applied for the position. There needs to be prompt review of resumes and applications submitted in application for the position. And it's really important that everyone in the company understand that even though you may have someone in the position on a visa whom you're wishing to have stay permanently and get a permanent residence or green card from this process, that the way the Department of Labor views this is that this employee who may be, for example, on an H-1B visa with your company and you're sponsoring him or her for a green card, they're in the position temporarily. Because an H-1B visa, all the temporary work visas that we have are, in fact, temporary work visas. They don't connote a permanent status. And so in the Department of Labor's view, while you may want that person to work for your company on a permanent basis in the future and you're sponsoring them, therefore, for a green card, the permanent position is not yet filled. That person is only here in a temporary position. So when you advertise the job, it's really important that everybody in the company understand that it needs to be a good faith recruitment process as if the job is still open. You may have someone in mind for it who's inside the company, but you have to act as if the position is open and still needs to be filled. And sometimes companies get in trouble along the perm process route because somebody in the company tells an applicant who applies for the job, oh, that's not a real posting. That we already have somebody for that job. That should never happen. It needs to be monitored very carefully, and there needs to be good communication within the company about what this process is all about so that it doesn't expose the company to any kind of liability, because you can be sure that if somebody applies for a position and is told something like that, it's very much within the realm of possibility that that applicant could be ticked off and could file a complaint with the Department of Labor, and the next thing a company knows, it's being investigated by the Department of Labor for failure to recruit in good faith. So it's really important that people understand the way the Department of Labor views the process. The PERM regulations require that the company or its counsel keep